UN Court's landmark ruling, Climate Change and Human Rights. Climate activists just won a historic victory, but will big polluters actually pay up? The UN's highest court delivered a jaw-dropping ruling this week, declaring climate action a human rights duty and paving the way for reparations from major polluters. Here's everything you need to know about this seismic shift in global climate justice. Correction. Earlier reports incorrectly cited 2,000 climate-related lawsuits. In reality, the correct figure is 3,000, and counting. This adjustment alone highlights how climate litigation has exploded across the globe. We're glad to set the record straight. The ruling, a new era of accountability. The International Court of Justice, ICJ, dropped a bombshell advisory opinion that could redefine who's responsible for climate harm. After years of lobbying by Pacific Islanders, Vanuatu, and youth activists, the court ruled that all nations must act decisively against climate change, and those who don't may face reparations. But here's the kicker. The ICJ explicitly linked climate change to human rights, stating that a clean environment is essential for the full enjoyment of other rights, like life, health, and property. This is a door opener to shut down fossil fuel giants' impunity, said Nikki Reisch of the Center for International Environmental Law. Her team had been tracking 3,000-plus climate lawsuits worldwide, cases that could now gain traction, citing this decision. Paying the price, restitution versus compensation. The court outlined two ways nations might be held accountable. 1. Restitution. Rebuilding damaged ecosystems or infrastructure harmfully impacted by climate change. For example, repairing reefs destroyed by rising seas. 2. Compensation. Monetary payouts when restoration is impossible. For example, calculating losses from droughts displacing communities. But here's the challenge. Climate damage is rarely reversible. The ICJ acknowledged that pinpointing exact culprit nations and quantifying harm is notoriously tricky, like proving who caused specific hurricanes amid a century of emissions. A global justice watershed, with caveats. Legal experts like Maria Antonia Tigre at Columbia Law called the ruling extremely groundbreaking. However, implementation remains murky. The ICJ's opinion is non-binding, relying on voluntary action, a deep flaw, argues Feluke Adebisi of the University of Bristol. International law itself is built on the exploitation of colonized and marginalized peoples, she noted. Even a progressive ruling struggles to dismantle systemic inequity. Shutdown, the U.S. pushes back. The U.S., alongside other major polluters, fought the ruling, arguing, climate responsibility should be determined by treaties like the Paris Agreement, not human rights law. Only emissions post-1990 should count, avoiding liability for decades of fossil fuel expansion. Compensation should be decided by nations, not courts. The ICJ rejected most of these arguments, but the U.S. has already distanced itself. American courts rarely cite ICJ rulings, and the U.S. withdrew from the court's compulsory jurisdiction decades ago. Yet, experts suggest indirect impacts, state laws, activist strategy, and international political pressure. What's next? For Pacific Islanders facing annihilation by rising seas, this ruling is life-saving symbolism, but real-world change will depend on 1. Grassroots action. Tigre predicts the ruling will embolden local U.S. governments to pass stricter climate laws, especially as federal action stalls. 2. Global momentum. Reisch expects this decision to influence court cases worldwide, creating a template for holding nations' polluters to account. 3. Youth power. The case was spearheaded by Pacific students, a reminder that climate justice often begins with marginalized voices. The big question, will Goliaths pay up? Adebisi raises a critical point. The ruling assumes major emitters like the U.S. and EU will voluntarily adopt reforms. Powerful nations won't surrender privilege easily, she warns. The system remains rigged against smaller, poorer states. Do you think this ruling will move mountains or get buried in bureaucratic quicksand? Share your thoughts below. And remember, truly independent journalism depends on readers like you. Thank you for standing with us. UN Court's shocking climate ruling. Countries face legal hell. Imagine a world where countries are held accountable for the environmental damage they cause. This is the groundbreaking shift we're seeing in climate policy. But here's where it gets controversial. The United Nations highest court has just issued a landmark opinion that could reshape how nations address climate change. This roundup delves into this and other top climate news from the past week, exploring how the legal landscape is evolving, the future of fossil fuels, and even countries not part of the Paris Agreement are still obligated to protect the climate under human rights and customary international law. This advisory opinion is being hailed as a powerful tool for those most vulnerable to climate change, such as developing nations and indigenous communities, who can now sue countries for historic emissions or failure to meet climate commitments. As Vanuatu's climate minister Ralph Regenvanu put it, this advisory opinion is a tool for climate justice, and boy has the ICJ given us a strong tool to carry on the fight for climate justice. Next, let's talk about the future of energy. UN Secretary-General Antonio Guterres has declared that a transition from fossil fuels to renewable energy is inevitable, stating that fossil fuels are running out of road. Guterres urged nations to invest in low-carbon energy sources to enhance grid resilience and reduce costs for consumers. The cost of renewables has plummeted in recent years. Solar energy, which was once 4 times more expensive than fossil fuels, is now 41% cheaper. A report from the International Renewable Energy Agency found that over 90% of global renewable power projects are now cheaper than fossil fuel alternatives. Guterres also called on major tech companies to commit to using 100% low-carbon power by 2030. Now, let's look at some other top nature and climate stories from the week. The European Union is considering simplifying its sustainability laws to reduce administrative burdens on companies and governments without lowering environmental standards. Meanwhile, the U.S. is grappling with a severe firefighter shortage as wildfire season peaks, with over a quarter of firefighting positions at the U.S. Forest Service remaining vacant. In Egypt, the ancient city of Alexandria faces the threat of coastal erosion, with 40 structures collapsing annually and beaches disappearing due to rising sea levels. In northern China, an unprecedented amount of rain, equivalent to a year's worth, fell in just 24 hours, causing flash floods, power outages, and infrastructure damage. Scientists are also sounding the alarm about declining seabird populations in Peru, where guano coastal bird numbers have dropped by more than 75% in the past 3 years. Lastly, let's explore some insights from the World Economic Forum. Traditional water risk management approaches are no longer sufficient, as severe flooding, pollution, and declining water quality pose critical global challenges. AI-driven systems are emerging as a new benchmark for intelligence, precision, and responsiveness in water risk assessment, potentially marking a turning point for global water security. Additionally, the true value of climate adaptation efforts is often underestimated, and coordinated, systems-level approaches are needed to manage the complex interconnections between energy, food, and water systems. This is just the tip of the iceberg. As we navigate these challenges, it's crucial to stay informed and engaged. What do you think about the ICJ's advisory opinion? Should major tech companies be required to use 100% low-carbon power by 2030? Share your thoughts in the comments below. World Court rules. Countries legally obligated to curb emissions and protect climate. The World Court has made a groundbreaking declaration. Nations are legally bound to reduce greenhouse gas emissions and safeguard our climate. This ruling from the United Nations primary judicial body emphasizes that countries must act diligently and collaboratively to meet these environmental responsibilities. At the heart of this obligation lies the Paris Agreement, which aims to limit global temperature rise to 1.5 degrees Celsius above pre-industrial levels. The court's decision underscores that if nations fail to uphold these commitments, they could face legal repercussions, including the need to halt harmful practices, provide assurances against future violations, and offer reparations based on the specific circumstances of their actions. In a heartfelt response, UN Secretary-General Antonio Guterres celebrated this historic ruling, describing it as a triumph for our planet, a win for climate justice, and a testament to the influence of young activists. His remarks came shortly after he addressed member states about the inevitable transition to renewable energy. The court's reasoning is rooted in the commitments made by member states to various environmental and human rights treaties. These treaties, which include agreements aimed at protecting the ozone layer, the Biodiversity Convention, and the Kyoto Protocol, obligate nations to preserve the environment for current and future generations. Moreover, the court highlighted that a clean, healthy, and sustainable environment is essential for the realization of numerous human rights. As signatories to many human rights treaties, including the Universal Declaration of Human Rights, countries are compelled to tackle climate change to ensure these rights are upheld. The case's origins trace back to September 2021, when Vanuatu, a Pacific island nation, sought an advisory opinion from the court regarding climate change. This initiative was driven by the youth organization Pacific Island Students Fighting Climate Change, which emphasized the urgent need for action, especially for vulnerable small island nations. After rallying support from other UN member states, Vanuatu successfully pushed for a resolution in the General Assembly on March 29, 2023, asking the International Court of Justice, ICJ, to clarify two key questions. 1. What are the obligations of states under international law to protect the environment? And 2. What legal consequences do states face if they harm the environment? The UN Charter permits the General Assembly or the Security Council to request the ICJ to provide advisory opinions. While these opinions are not legally binding, they carry substantial moral and legal weight, helping to clarify and shape international law by outlining the legal responsibilities of states. This case marks a significant milestone for the ICJ, evidenced by the unprecedented number of written statements, 91, and the participation of 97 states in the oral proceedings. Commonly referred to as the World Court, the ICJ resolves legal disputes between UN member states and offers advisory opinions on legal matters referred to it by UN bodies and agencies. It is one of the 6 principal organs of the UN, alongside the General Assembly, the Security Council, the Economic and Social Council, the Trusteeship Council, and the Secretariat, and notably it is the only one not located in New York.